it has already been said, we are going to present the title, our paper basing on the title, Culture and Design Thinking, an Anatomy of the Law and Practice in Business Development. Basically, the objective of this paper is to enlighten ourselves on how the law and how the legal framework in Tanzania, it governs, it guides business development in different areas. And we are going to tell, using this presentation, that the legal framework in Tanzania has designed and has set in framework different rules and regulations that they are and they are supposed to be abided by all business people in Tanzania for the business development. The outline of this work is, first of all, we are going to have the understanding of what is culture, what is design thinking, and also design rights as an outcome of design thinking. And also we are going to explain about intellectual property being a property that is also an outcome of design thinking. And again, in this paper, we are going also to explain as what are the laws governing this business culture or business community here in Tanzania. And last, we are going to see what is the practice that is brought by the law, and also we'll have the challenges of the law again. I will start by explaining what is culture. Culture is defined as a state of development in art and thought, and in a prevailing society which represented in various levels by knowledge or training. And this culture, as it has been defined there, it refers to the norms and attitudes that are there in a given society. It could be a business society, a legal society, and others. And we have explained about different cultures, like the legal culture, whereby it is understood a legal culture to be the norms and attitudes that defines the legal community and also applied in the legal community. You would see from this definition that in every community or in every society there is a certain culture, there is a certain attitude that needs to be practiced. Now, in that sense, being the norms that need to regulate a legal perspective of a thing, the legal culture, it should not be left behind in a business development. And come to what is a design thinking. Design thinking itself is defined as a discipline where the designer in a business enterprise develops and uses various methods of technology as viable strategy to add value to the business. Now, with design thinking, these ones are the designs of a person, the features that a person develops to add value in business out of his thinking. It's a product of his mind. That is what it's to be understood as a design thinking. Now, design thinking, being a product of mind, being an item, being a feature that comes out of a person's mind, design thinking, it creates design rights. It means out of that thinking, out of a feature that a person has developed from his mind, he has a right. He has the law needs to protect the product of his mind. Now, because of that, there comes design rights, being the entitlements a person has out of his or her thinking. And we can define design rights as protection for aspects of the appearance or arrangement of commercial exploited articles, which fall between protection of patents and copyright. Now, these design rights, they are entitlement, they are protection a person has, a person's acquire out of a product of his mind. Now, being a right a person has and being a product of mind, out of design rights, we get a property because of that right a person has, because of the outcome a person has developed from his or her thinking. Now, what is a property? Because of that design thinking and the design right a person has acquired. What is a property? We can define a property as a valuable object, item, thing, or substance which a person possesses or a person owns. So, design rights, they create proprietary rights because they are a product a person has developed from his or her thinking. Now, because of that, because of it being a property of his intellect, from the legal perspective, we got an example of proprietary right to be an intellectual property. That is to say, the legal framework in Tanzania protects the intellectual property a person has or a person acquires out of his design thinking. You would ask now, what is an intellectual property? An intellectual property, these are the property which a person possesses out of his intellect, out of his mind. That is a product, a property or object a person has developed from his thinking, from his intellectual capacity. Now, because of that, as a product or as an object a person owns, because of his intellect. In Tanzania, the legal framework has created the legal regulation rules to protect and to ensure that a person who possesses those intellectual property to have protection of the product, to have the protection of his or her property for business development. I'm going to explain some of the laws, and my colleague will proceed as the laws that protect those intellectual properties that a person, the laws that protect the intellectual property which a person has and he uses them in business. One of the laws that protect those intellectual property, it is the Constitution of United Republic of Tanzania. Under Article 24, the Constitution provides for the right to property, which it is a fundamental, it's among the fundamental rights a person has as a human being, the right to own a property. You being a human being, on any field, you have a right to own a property of any kind, be it a real property or a personal property with the like of the intellectual property. Now, by virtue of that right given to you, or the right that you inherit as a human being, and as provided in the Constitution, it tells us even the intellectual properties which a person innovates or a person develops from his work of minds, they are also inclusive in that protection. So let's say a person has developed a feature which is unique. Because of this protection under Article 24 of the Constitution, that property a person will have exclusive rights to himself. And in case of any infringement or any violation that a person uses the same without permission of the owner, you will enforce it in the courts of law. And the good thing about these provisions of Article 24 is that the right to own property is equally enforceable like other human rights, the like of the right to life. You can enforce, if a person infringes your right to own a property, you can enforce the same to the courts of law, just as if a person infringes your right to life. Another law that protects these intellectual property is the Copyright and Neighboring Rights Act. This is the law that provides for the protection of intellectual property rights under Copyright and Neighboring Rights Act, under Copyright and Neighboring Rights, which to include literary work, artistic work, to mention a few. In this act, there are economic rights that are protected, economic and moral rights of the owners of those intellectual rights, such as the authors of different literature, and also if a person infringe, that is, if a person use those literal or artistic work without permission of the owner of that right, he will suffer different sanctions as provided by the law, including sanctions, criminal sanctions, such as payment of fines up to the extent of 5 million, and imprisonments to the term of 5 years. But these rights, they don't come automatic. That is, if you have registered, if you have create your literal work or your artistic work, then you are automatically protected. No, it is subject to registration and getting a license over that property. That means if you have not got a license from the authorities over exclusive rights, be it economic or moral rights, if a person infringes your right, you will not be protected because you have not got a license to that effect. And so if you have a license, if you have registered yourself for the protection of your literal works, if a person once infringes that right, you have to enforce. You enforce your right under court processes. Another law, it's the Patent Act. It is the act for monopoly of an invention after application for patentability, application and examination for patentability. That means this act, it has been put in place in order to protect the innovations a person comes with as their intellectual properties, and after your work has gone through examination of patentability, that is when you will have protection under the Patent Act. And therefore, the tools that are used in protection under this act, it is, first of all, there has to be a registration. Like I've said in the previous law, you must register your work. You must register your work, and when you register your work, it's when you have exclusive right over others who are not owners of that work. And if anyone who infringe your right over a patentable product, he will face the hands of the law by sanctions such as injunction. That is, of course, upon application you apply to court for an injunction for that person not to continue with the use of your patentable work. Lakini there is also payment of fine. There is also payment of fine, which in some legal writers they have commented on these fines under the Patent Act to be of trivial amount, but because it is the law that is in force right now, it is the law that is in place right now, business people, they are not to disregard it if they want protection for their intellectual rights. I'll end here and welcome my fellow presenter. Thank you.
Very much. I will proceed with other laws such as the Trademark and Service Marks Act. Now, the act began historically, it began by branding. If you will see, various cattle are branded certain marks to identify that this is my cow. If you see various goods that were shipped from one place to another, they used to be, the boxes, they were branded by using certain marks. Now, that was the history of Trademark and Service Mark Act. Now, this act in Tanzania, basically, it regulates or it provides or it covers for matters pertaining to prohibiting use of marks that are similar to another person's trademark. So you have a business, but your business will not prosper if another person uses the same mark as yours. It will lead to derogation, or it will lead to reduction of profit to your business. Now, the act requires every person who uses or wishes to use a certain mark for promoting his business or for making sure that development of his business occurs well, then the law requires or offers protection for those business persons or various traders. Now, it does not only cover for traders, but also those who engage themselves in various service. For instance, an institution provides education service. You will not find an institution that has a mark or a logo as the one that we use in Jordan University College. If one exists for that matter, then the college might sue or may sue for any loss that might have been caused by that other proprietor or service of provider. And another law is the Merchandise Marks Act. Now, the Merchandise Marks Act deals with items that are forgery or that are subject of forgery. Now, an item that is subject of forgery is also a hindrance in business development, because if you have a certain good with a mark that is not of the one which you expected to purchase, for instance, a certain brand, I do not intend to promote or advertise such good, but if you have a good, for instance, shoes like Hugo Boss. Now, if you have a similar, let us use Bata, the ones that we have in Tanzania. If you have a similar shoe with the same mark, but it is not the reality, or if you will hear of cases that there are iron sheets that are said they come from South Africa, but actually they are made somewhere in behind the compound of a certain house. Now, this law protects such goods from counterfeiting. Counterfeit, in other words, the common word that is known or is used is bidhaa feki. So how do you regulate counterfeits in the market? It is by ensuring that you have a legislation which will confer protection to whoever tries to counterfeit or to copy or to make a similar good of the same nature for the purposes of gaining economic advantage. Now, to the real proprietor, it will diminish his profit, and thus his business will not actually develop or otherwise. Now, this law also provides for protection of intellectual properties in the internet or in the information communication technology. If you see its amendment of 2012 under section 18 capital B and capital C, it prohibits advertisement or hosting website that offer for sale counterfeit goods. So if you have a website or if you have a page, for instance, business are now conducted online. We have Instagram, we have Twitter, a number of social networks have turned into online shops. Now if you host a website or if you host any page and you offer for sale a counterfeit product, now the law will also deal with such person who has not verified if this good is genuine or otherwise. Therefore you have to only, the law also will deal with such persons, but also on the other hand, it protects whoever has such business online to ensure such person has protection and his or her business is well developed through the legal protection. On the other, another piece of law is the Plant Breeders' Rights Act. You might have heard of genetic modified organisms or GMOs. Now, in Tanzania, this is the act that protects or covers or offers for protection of GMOs. Whoever invents a food product or a plant that will survive in the harsh climatic environment that we are in, then this particular person is also guaranteed or is also offered protection under the law for that invention or that innovation of ensuring that we have food products or economic products such as trees that can grow in a short duration of time, that can survive harsh climatic conditions. Now this thing has been made or it is given protection under the law, and whoever, if it is a company or if it is an individual, if it is a group of people that have formed a partnership, they will also get protection upon registration and following certain formalities, and through that way actually their business will develop and prosper. The other law is the Cyber Crimes Act of 2015. You will wonder why a criminal statute has to be mentioned here. But under section 24, it criminalizes any violation of intellectual property right that has been stated earlier in the internet or in the computer system. That is how the law is applicable. So you are not safe if you hack or if you download a creative work of a person. For instance, a person has the trending movie now is Black Panther, isn't it? Yes, people are talking about Wakanda and all that. Now, if you are found having downloaded, or if you are found in possession of such movie, which worth $1 million of money, then the Cyber Crimes Act under Section 24. Now, take an example: if the movie has been created or has been expressed in Tanzania by the copyright laws, then such person will be considered as to have violated the intellectual property of those who people have labored and tamed in their mind that I want to give something of beneficial to the society by creating a certain literal artistic work for the benefit of improving my business industry in the movie or in singing or in writing books, but another person comes and take it for free without acknowledging or without ensuring that I get my economic rights. Now, the Cyber Crimes Act will also protect intellectual property owners or proprietors in the internet. The other law that is in place is the Electronic Transaction Act. This law deals with how you can conduct business, specifically whether you can enter into agreements or whether you can conclude contracts online. This law also says if you have your business and you want to conclude contracts online, the same is possible. So business has developed, or the culture or law has facilitated in ensuring business develops by trying to go with the technology or with the development of technology, by ensuring that protection is conferred everywhere, rights of the people are ensured in each or most of the places. Since the role of the law is to regulate, is to provide for the rights, is to ensure that it offers protection to various people. Other legislations that play part in ensuring that culture is enhanced, design is protected, and business is developed or managed. We have the Companies Act, which shows how a person can register to have a company to ensure the business is run smoothly. And also we have the Business and Licensing Act, which also has the same role. You want to conduct a certain business, it is not a company, but you want to be a sole trader, you want to be a partner, to have a partnership, you want to conduct a joint venture, then the Business Licensing Act will actually say you must have a certain license before you conduct that business which you wish to develop or which you wish to manage. Now, on the practical aspect or on the legal aspect, what does the practical aspect mean? The practical aspect outlined here is not on the procedures or on the steps of what a person can do to start a business and manage a business legally. This is not the concentration. The concentration here is on selected cases as to how the law protects those intellectual property proprietors or owners. Now, you will see a number of cases. For instance, the Kibomatch Group Limited versus HS Implex. It is reported in the 2001 Tanzania Law Reports, page 152. And in that case, I will not go into the facts of the case, but the decision was that to see that protection is actually offered in Tanzania to these business owners for the purposes of developing your business, then they said that if a person breaches or violates an intellectual property, for instance, a trademark for this case, then you can go and ask for an injunction. An injunction is that I am stopping this particular person from conducting such business because such business is injurious economically to my business, which is lawful, which is registered under the laws. So through that way, you'll actually develop because there will be no unfair competition from the one who has created a good that is not of true nature vis-a-vis the one who has gone through the proper legal channels and you are recognized. Now, in another practical aspect, we have the vitamin food, the second case, which also shows how a protection can be offered. And the best way to be protected under the law is through registration. And they say companies usually register to protect their products for the purposes of maximizing profit and to develop. Another case is Q European Holding. They are all Tanzanian case. And as you can see there, it says upon registering of a trademark, it confers exclusive right. When we say exclusive right, we refer or we mean the right to the particular owner in exclusion of all others. So any other person is not allowed into that enjoyment of the trademark or copyright or patent that you have designed or created. If you want to enjoy, then you can only enjoy through seeking permission, and you will be allowed by being given license, by being given or through purchasing and so forth. Now the other part of the discussion is we have tried to outline the challenges that exist in design and development. So if you read the laws, you will find that there are insufficient penal sanctions compared to what the proprietor or the infringer, not the proprietor, compared to what the infringer has gained. So there are insufficient penal sanctions. The law, not all, some of the laws do not keep abreast with the advancement of technology. For instance, in Tanzania, we do not under patent. In other jurisdictions, we find that patent is protected, for instance, software, computer softwares. Computer software are protected under patent. But in Tanzania, we do not protect computer software, rather we protect computer programs. Now, the program deals with the coding and so forth. Now, if you have your software, which you have developed, legally it has no direct legal protection. Now, that is one of the examples in which we were identified there. Another one is inadequate civil remedies. Most of the cases will go under the umbrella of tort or tortious activities. Few laws provide for direct civil remedies. Few laws provide for direct civil remedies. However, another challenge is that most of the people are not interested to protect their intellectual property. I have written a book, I've seen it is copied somewhere, I'm not interested. I will not sue, because in Africa we do not sue. We are afraid if I sue today, tomorrow I will go to the same person and ask for help, and they will not help me because yesterday you sued my uncle or you sued my friend. So we do not have the culture of needing to enforce our rights. The opportunities. Now, what are the possible ways that we can adopt to resolve the challenges? Possible, we can say we need to adopt a single intellectual property policy. We do not have a single intellectual property policy. You will find we have the Copyright Neighboring Act. We have a number of laws, and each laws, most of them have their own independent policies. Now, from the policy, it is where we have the law. The other one is to improve human capacity in protecting intellectual property. Improving human capacity that you have your intellectual property, register it if it requires registration. Adopt a framework legislation to easily protect intellectual properties. Now, why adopt a framework? When we say a framework, it means a whole bunch of law without having these minor legislations. You will see here we have identified at least to 10 or 7 or 8 pieces of legislation. They are very confusing. But if we have one single framework law which covers for most of the essential things, then that will be easy. That will be easy to offer protection. Probably people do not know that if I develop a certain item, in which law will I protect? Most people do not know that. But if you have one law, for instance, as how we have the Environmental Management Act that provides for the most of the things, then that is very easy in protecting the rights. The other one is to establish a national intellectual property organization. If we have a nationwide intellectual property organization, rather than having COSOTA, which only deals with copyright materials, such as books, songs, movies, but if we have a national intellectual property organization, it will assist in ensuring proper protection. For instance, patent is not protected. We have the patent office, yes, and we have the COSTECH, Commission for Science and Technology, which tries to oversee issues of patentability. But if we have a one national intellectual property organization, it will assist in overseeing how intellectual property rights activities are handled. And also, in the event of enforcing the rights, probably we could have a special court that has specific jurisdiction over intellectual property rights. For what purposes? If you see that my rights are protected in a certain way, expediently, then that will encourage people to innovate more, to develop their business, and things will prosper nice. In conclusion, we say that most of the laws in Tanzania enhance culture, a culture of being creative and innovative. Why? We have seen examples of laws that offer protection to those who innovate, but also we have seen that the laws ensure smooth development of business, whereby they confer for legal protection. But another way is that we have laws also that legal management is crucial or is essential in ensuring that business is developed. And lastly, we say due to the importance, then intellectual designs must be protected and managed in the way that they will prevent derogation and damage. And the management of this is through the legal framework, as we have stated earlier. Thank you for listening.